thou shalt avoid hostility. I grew up in Detroit, as I've said, and I was one of 7 kids, and my dad and my 2 oldest brothers made very good livings selling to the automakers and the other big companies in Detroit. They did very well. But the thought of them filing a bid protest, a lawsuit against one of those customers if they didn't win a particular contract or a particular bid, that thought would never have occurred to my dad and my brothers. You sharpen your pencil, you take a few more out to lunch, which they could do then, but you don't sue them, right? I mean, and yet, in our world of government contracting, bid protests are pretty common. Several thousand a year are filed at the GAO. And so it's a different marketplace. And we have claims, right, under the Contract Disputes Act. But even though we have these dispute resolution techniques available to us, you will be far better off to try to resolve any disagreements you have with your potential customer or your actual customer at the lowest possible level, at the earliest possible time, with the least amount of hostility, and try to do it without lawyers on the front line. They can be in the background, they can be advising you, but the minute lawyers enter the picture, the game has changed. Now you got to have the government lawyers. And consistent with this philosophy of avoiding hostility, understand that the tone of your correspondence with your customer is very important. Now, maybe you were at business school at one point in your life and you learned how to write a business letter and your professor talked to you about tone, but I don't remember hearing a word about it in law school. And yet, I can tell you that the tone of a letter, or today an email, can leave and have an impact on your customer. Putting something in all caps, demanding something, underlining something. Think about how it's going to be received at the other end. Avoid making written threats or using inflammatory language. Never, ever threaten a contracting officer. You do this or we'll sue you. You do this or we're going to file a bid protest. No. You can send the same message without the hostile tone. Now, there is also in FAR Part 33214 2 paragraphs about something called alternative dispute resolution, ADR. And if you look at it and you talk to your lawyers about it, if you are a lawyer, you know about this, it means that, yes, we can go to the boards of contract appeals. We can go to the United States Court of Federal Claims, but even though we're there, we can resolve our disagreements in this dispute through alternative dispute resolution rather than letting it go to trial in front of the judge. Now you say, why would we want to do that? Well, number one, it's usually far cheaper. Number two, the parties get to control the schedule. And number three, if it works out, and it literally did every time I tried it in my career, you haven't burned the bridges between the parties. We've resolved it in a professional, expeditious way, and I haven't had to go scorched earth through scorched earth litigation to do it. So ADR is a dream. And if you read the FAR provision at 33.214, you'll see that you can do this during the contract. If you see a problem brewing, you can write to the CO and say, hey, or a CO can write to the contractor and say, hey, I think we've got a problem on the horizon. Can we sit down and talk about it? Perhaps do ADR about this? Let me tell you, that gets people's attention. And again, it doesn't have to be done in a hostile way. Make it professional. Now, another reason to avoid hostility, if you think about it for a second, is past performance. Past performance is something that was the one of the things created by FASA and FARA in the mid-90s. The Federal Acquisition Streamlining Act and the Federal Acquisition Reform Act. And basically, it allows potential buyers, agencies, to take a look at your track record. And that's their database goes back 3 years, right? Because you're going to be evaluated after you complete every federal contract, and on a multi-year contract, every year of your contract. And these things hang around your neck for 3 years. And they look at things like the contractor's commitment to the best interests of the government, for example. So yeah, past performance reports can have a huge impact on your business success. And that is why we avoid hostility, because it will pay off in terms of how we are evaluated at the end of the contract and during.